Hi everyone, welcome back. So, in my previous session, we were talking about the partnership, correct? Now, today, before I introduce you to the next topic, I thought I will first take you back to early 2000s. Okay? So, Ravi and Meera were two brilliant chartered accountants. Okay? And they decided to start their own practice in Bangalore. They trusted each other deeply, they worked hard, they built clients also slowly. So they registered a partnership firm under the Indian Partnership Act 1932. Everything was going well until that one day. Okay, so Ravi, without informing Meera, fully signed off on a client's financial certification that later turned out to be fraudulent. Now, the client defaulted, creditors filed a lawsuit. Now, under the Partnership Act, Ravi was liable, but Meera was also personally liable, even though she had no role in the mistake. Her personal savings, her house, her family security, everything was now at risk. Why? Because in traditional partnership, every partner is the agent of the firm and also the agent of the other partners. And unlimited liability meant personal exposure. Now, this was not just Ravi and Meera's story. Across India, chartered accountants, company secretaries, lawyers, consultants, architects, almost everybody who started partnership faced the same fear. One partner's mistake can destroy all the partners in the firm. Now, at the same time, they did not want to form a company also because forming a company means attracting too many complications, board meetings, share capital requirements, rigid structure, so many things. But they actually were looking for flexibility in partnership, but also protection like a company where the liability is limited. So, India needed something in between a partnership and a company. Okay, so the government of India introduced an act called as Limited Liability Partnership Act 2008. Okay, now the act came into force in 2009. It created a hybrid structure, a partnership with limited liability and also a corporate body but with flexibility. Now, this was revolutionary for Indian professional and startup ecosystem. Okay, so now just imagine how LLP became a game changer. Now imagine Ravi and Meera forming an LLP instead. If Ravi commits the fraud, the LLP is liable, Ravi is liable, but Meera's personal property is protected unless she was involved. Now, this is called limited liability with separate legal entity, and that is why LLP was born. Okay? The concept of LLP originated in the UK and was gradually adopted worldwide. In India, the need was strongly felt by professional firms like CAs, CS, and lawyers. Traditional partnerships exposed partners to unlimited liabilities, and companies were too compliance heavy for small professionals. Therefore, like I already told you, the Indian government introduced the LLP bill in 2006. The act was passed in 2008 and it became effective in 2009. The Ministry of Corporate Affairs MCA administers LLP in India. Okay? So, let's now formally understand the meaning of LLP, nature and characteristics, incorporation process, and also let's compare it with partnership and company to understand the concept better. Okay? Always remember, law is not just about provisions and sections. It is also born out of real life business problems. Okay? Let's start with the definition of LLP. So, an LLP is a partnership formed and registered under the LLP Act 2008. So, unlike the traditional partnership, LLP is a body corporate. It has a separate legal entity and also perpetual succession. This means LLP continues irrespective of the changes in the composition of the partners. Okay, let's now understand the core features, nature, and characteristics of LLP. So, firstly, like I said, LLP is a body corporate, which means it has a separate legal entity. It is a distinct person from that of its partners. For example, if ABC LLP enters into a contract, it is the LLP that is liable, not the individual partners personally. Okay, and I also said that LLP has a separate legal entity. Now, what does that mean? Just like a company, even LLP can own a property, can sue anybody, and can be sued by anybody, and it can also enter into contracts in its own name. Now, this is a major shift from traditional partnership. Okay, and also LLP enjoys perpetual succession. What does that mean? It means the death, insolvency, retirement of the partners does not dissolve the LLP. It continues unless wound up according to law, just like in the case of a company. And also, one of the most important feature is that LLP, the partners have limited liability. That is, liability of the partners is limited to their agreed contribution. A partner is not liable for independent or unauthorized acts of other partners. For example, if partner A commits fraud without partner B's knowledge, partner B is not personally liable at all. Next, we understand about mutual agency. Now, in traditional partnership, every partner is the agent of the firm and also the agent of other partners. Whereas in case of LLP, partner is the agent of LLP but not agent of other partners. Now, this is a very important conceptual distinction between traditional partnership and the LLP. Okay. Now, let's also understand a feature regarding the minimum and maximum number of partners required. So, to start an LLP, minimum 2 partners are required, which means at least 2 designated partners, and there is no maximum limit. If the number falls below 2 for more than 6 months, the sole partner may become personally liable. Okay. Now, let's understand about designated partners. Now, at least 2 individuals must act as designated partners in an LLP. Now, they are responsible for compliance, filing documents, and legal formalities. Now, at least 1 out of the 2 designated partners must be a resident in India. Please note, at least 1 out of the 2 designated partners must be a resident in India. Okay. Then let's understand about LLP agreement. So here the rights and duties are governed by the LLP agreement. Now, in absence of such agreement, the first schedule of LLP Act will apply. Now, this gives flexibility just like the partnership. Okay. So now let's understand incorporation or registration of LLP. So, is registration of partnership compulsory in India? If you had seen my previous videos, you will know the correct answer. The answer is no. Correct? So, partnership need not necessarily register. But LLP, the registration is a must as per the LLP Act. Okay? So, now let's understand the registration or the incorporation process for an LLP in India. So, firstly, the LLP has to reserve its name by giving an application to the registrar where the name of the firm should end with the word LLP. Okay? And at the time of incorporation, for submitting the documents must clearly state the name of the LLP, proposed business, address of the registered office, details of the partners, details of the designated partners. And this must be signed by the partners and it should be filed with the registrar. Okay. Then a statement of compliance should be filed, which is actually given by a professional. It can be a CA, CS, CMA or an advocate who will certify the compliance and legal requirements. So this is called as a statement of compliance which has to be filed along with the document. Then, once satisfied, the registrar will issue a certificate called as Certificate of Incorporation. From this date, that is the date on which the Certificate of Incorporation was issued, LLP becomes a legal entity. Okay. Now, LLP agreement must be filed within 30 days from the date of incorporation. Okay. And the contribution to an LLP can be in the form of cash, it can be in the form of property, it can be in the form of intangible assets or even services. Unlike company, contribution need not be only monetary. Okay. And let's now understand about the accounts and audit of LLP. Now, LLP must clearly maintain proper books of accounts and the audit is required only if the contribution by the partners exceeds a prescribed limit or if the turnover exceeds a prescribed limit. Otherwise, audit is not necessary. Now, compliance burden is lower compared to the companies. Okay. Now, this is about registration or incorporation of an LLP. Now, the concept of LLP becomes much more clearer when we are able to differentiate it with partnership and company. Okay. So, let's now consolidate understanding through comparison between LLP and traditional partnership. Okay. So, for the LLP, the governing law is LLP Act 2008. For the partnership, it is Indian Partnership Act 1932. For an LLP, it has a separate legal entity, whereas for a partnership, there is no separate legal entity. In case of LLP, the liability of the partners is limited. In case of partnership, the liability of the partners is unlimited. And in case of LLP, registration is compulsory, that is mandatory in India. And in case of partnership, registration is only optional. Okay. And LLP has a perpetual succession, whereas partnership does not have perpetual succession. Now, very importantly, in case of LLP, partner is an agent of LLP only, whereas in case of partnership, partner is an agent of the firm as well as the partners. Okay. Now, let's understand how LLP is different from the company. Okay. So, in case of company, The governing law is the Companies Act 2013, whereas for an LLP it is the LLP Act. The internal structure is rigid in case of a company, whereas it is flexible in case of a LLP. Now, with regard to compliance, it is too high in case of company, whereas it is moderate in case of LLP. Now, with regard to ownership, the partners are the owners in case of LLP, and in case of company, it is the shareholders. And the management of the LLP is carried on by the partners itself, whereas in case of company, it is the board of directors. Now, audit is subject to conditions in case of LLP, whereas audit is mandatory in case of companies. Okay. Now, this makes us more clear with regard to the concept of LLP when we compare it with company as well as partnership. Okay. So with this, we complete week 6, where we have understood about both traditional partnership as well as LLPs. Now, before I wind up, I would like you to understand and think about, if at all you are starting a business, please ask these questions and then decide what will be an ideal organization for you. Okay. So, the first question is, what is my risk exposure? Do I want limited liability? How much compliance can I handle? And do I need perpetual succession? Now, answer these questions, and this will actually help you to choose between a partnership, LLP, and a company. It is not just about the legal theory, it is about strategic decision making when it comes to starting a new form of business organization. Okay, so with this, we have completed understanding of traditional partnerships as well as LLPs, that is limited liability partnership. Okay, so see you in the next week with a new topic. Until then, keep revising the concepts of partnership and LLP. Thank you. Have a good day.